Good morning. It is now 10 a.m. on Thursday, March 24th, and this is AccessHR presenting Understanding and Effectively Complying with the California Fair Pay Act. As I mentioned, my name is Priscilla Henley. I'm the Vice President here at AccessHR. We will be recording this session and posting onto our web portal for viewing later today. I have with me today Lee Clark. He is our Compliance and HR Director, and we are very excited for him to present today. I'm going to hand it over to everybody. Can please kindly mute their phones so that we do not have any echo or feedback throughout the presentation. And we will also have a Q&A at the end of this meeting. So Lee?
Thank you very much, Priscilla. I'm really happy today to be here and explaining this difficult to understand modification to the California Fair Pay Act. You will see that there are some interesting generalizations, and as we in the legal profession like to professionally call them weasel words, that have been placed in the law. So if you are a company of any size, this is going to be an interesting law to try to understand and comply with. So the purpose today is to try to make that a little bit simpler. Okay, good. Before we get started, I want to just take a couple minutes to go off presentation. I have been keeping AccessHR clients aware of changes in the law, and I think all of you probably have gotten inundated with important law changes and employment law in California for 2016. One of the things I want to highlight for you is the now absolute requirement that in your sexual harassment anti-bullying policy that you have, is that you have in your policy a formal written procedure for employees to file a complaint and for your procedures to investigate those complaints to be in writing, and then finally make sure that you can demonstrate that everyone has gotten access to it. Most of you are already doing that, but I'm still coming across people that have, companies that have one liner in their handbook saying we will investigate. Well, that's not enough. And so you needed that for a long while just for your own legal protection, but now it's law. So we're going to be talking about a couple other things that you might have to go in and look to your to change in your employee handbook. And so take a look and see that your sexual harassment policy is in good shape in terms of how I file a complaint and what you're going to do, and make sure. So our goals for today's presentation: understanding what the new law says, an overview of the new law, what it's all about and what's trying to do. And then, okay, so when I tell you what the law is about, then there's the, but what about this and what about that? So I'm going to spend a little bit of time just saying what the law is and then doing a kind of built-in Q&A, which I think will answer most of the questions that you might have on this. And then finally, most importantly, you know, where do we go from here? What do we need to do to comply with this law to keep us out of court? Okay? And it's going to require that you take a fresh look at how you administer wages, how you extend job offers. It puts added emphasis on job descriptions and performance evaluation. And it also highlights the fact that there is no such thing as salary privacy anymore within your company. That's that. Okay. So California Fair Pay Act made dealt in four major changes. Pay equity.
Excuse me, can everybody please mute their phones? Thank you.
Yeah, that's better. Somewhat. If you don't have your phone muted, then we're hearing all your private conversations, and if you're doing anything other than ordering Starbucks, you're in trouble. Okay, so this change in the law deals with pay equity between the sexes. It has nothing to do with EEOC in terms of minority groups, et cetera, all the other things that you have to worry about. This is just dealing with making sure that people get paid the same wage rates, have the same opportunities, regardless of sex. It also talks about pay transparency and that you have an obligation to let people talk about pay rates amongst themselves, amongst each other, and that you don't have anything in your employee handbook that says thou shalt not do so. That's always kind of in the law, but now it's really in stone. There's some changes to your record retention, how long you have to keep records of how you are providing wage increases, etc. And then there's a whole bunch of enforcement provisions, which of course we have in California. Okay. California Fair Employment Act, pay equity. Employees can be compared can be grouped even if they do not work at the same establishment, which is what the old law said, even if your employees are hundreds of miles apart. Hold the same or equal jobs, not the same job, not the job description header, it's same or equal jobs. Instead, it applies to employees performing, and this is the key. So write this, if you're keeping score at home, write this down. Substantially similar work. Okay? And you say to me, but that's a very nebulous term, and I'm saying to you, yeah, you're right. If I was a little bit more Machiavellian, I would say that the plaintiff's bar in the state of California had a lot to do with putting this law changed together, because substantially similar work, as we will discover, is a very, very broad term and deal with. Okay? So what you have to do is compare substantially similar jobs, and the level, and you can use the level of skill, effort, and responsibility required, and performed under similar working conditions. That's what the law says, and that's what you're going to have to deal with. Okay. We haven't had to deal too much with what we pay employees. I mean, of all the things we've dealt with over the years, you know, it's been one-on-one negotiations, and unless you work for a governmental agency or you're under a labor contract, this has normally been a situation where you bring them into the organization, you pay them hopefully based on what they're contributing, and it's kind of your business. That is anymore. California, in the preamble to the law, California's lawmakers said, we are way out of line in terms of what we pay male employees versus female employees. There is on average, there's an 84%, which makes a 16% spread rather between what females make and what males make. Now that's always a kind of a nebulous comparison, and I won't go into that, but it's interesting that the rest of the country. Nonetheless, there was obviously pressure to quote tighten this up. So that's why we went to our equal. It is now your responsibility to justify why people doing work that is, as I said, substantially similar, why there are discrepancies between male and females. It's your responsibility to justify that, and you can only use a certain number of limited factors. Okay. Here's what the law says. An employer shall not pay any of its employees at wage rates less than the rate paid to employees of the opposite sex for substantially similar work, there's that phrase again, when viewed as a composite of skill, effort, and responsibility, and performed under similar working conditions, except, and this is where you've got the out, except where the employer demonstrates that the wage differentials are based on one or more of the following factors. And some of these factors are the same as they were before the law was amended. So one is a seniority system. Now you can tell, by the way, that from some of these things that this is kind of old style employer situations that we dealt with in fact. When we were more of a manufacturing society and we had more labor contracts and we had more first-level employees, wage rates were often set based on a seniority system. I suspect of the people listening to this presentation today, probably none of you are doing that. If you are, that's fine. If you can explain wage differences based on a seniority system, you're golden. Okay, a merit system. Merit systems have a whole lot of complexities to them, and some people use them, and etc. Not too widespread. A system that measures earnings by quantity or quality of production. That's, you know, in my world, that's performance-based, but what really we're looking at here are people that work on piece rate and stuff like that. Okay, and then the fourth factor is a bona fide factor other than sex, such as education, training, or experience. Okay, this is where the game's going to be played at this D level. Okay, in most cases, what you're going to have to do if you've got a problem, Jennifer makes less than Robert, and you're going to have to do it on a basis of educating or experience. And even if there is logical differences, your responsibility is going to be to apply those things reasonably. What does reasonably mean? I don't know. They don't know. But, you know, you can't just, you know, you can't pull it out of left field and make it look like you're just doing it as a method to justify a system that's not right. Just explain the entire amount of the pay differential, not just the base pay. Okay, so you're dealing with total comp here. When you compare employee to employee B, you're not just looking at their going-in salary rate, but you're looking at bonuses and other tweaks that they may have. Okay, so you know, if you're trying to get around this law by, you know, bonusing up people on a non-sexual neutral basis, you're going to have a problem. We will, however, go into what I'm thinking might be a way to deal with some of the things that we're going to have to deal with. Okay. So let's look at this and say, okay, so you've told me that I now have to compare people in similar jobs, and I don't know what that means, and it's not at the same location, and they could have different job titles. Let's look at what this means. Let me ask some questions. Okay. There are many laws that prohibit pay discrimination. Might ask, why do we need another one? I haven't got an answer for that. But how is this law different than the laws that we've got? Okay. I threw up a little chart here to give you all the laws to be aware of that deal with equal pay, fair pay, however you want to classify it. The California Fair Pay Act deals on the basis of sex only. Again, none of the other factors. Substantially similar conditions is the comparison group. And you will see it's normally situated employees is kind of the thing. And New York, by the way, passed similar legislation, and they tightened it down a lot more in favor of employers. So you don't have this kind of nebulous, where does my employee work, etc. But it's similarly situated work. It's not involved with the same location as it used to be. This isn't an intent-based law. So if you intend to be off track here, that doesn't matter. It's just where are you? And again, you must explain the entire age differential if there's a disparity.
Can you mute your phone, please?
Okay. Again, does this apply just to base pay? What about other forms of compensation? Okay, here's their definition in California. Wages include all amounts for labor performed by employees of every description, whether the amount is fixed or ascertained by the standard of time, task, P, good stuff. So the important thing is it's not just base pay or salary, but other forms of compensation, bonuses, commissions, etc., are taken into consideration. Okay. Answer question number 3. Grouping employees. How do I do that? This is going to be one of the 2 most difficult things to deal with in complying with the law. Again, substantially similar work that requires substantially similar skill, efforts, and responsibility, and which is performed under similar working conditions. Okay, so that's what we're dealing with. So let's take a real life example. Let's say that you've got people in different classifications, such as secretary, senior administrative assistant, support analyst, etc. Are these jobs substantially similar? Well, you're going to have to look at that and see, which means you're going to have to get inside those jobs and find out what's going on. Let me give you another kind of example where you might have an interesting situation. Let us assume that you're comparing project managers. Okay? Project managers.
I wrote him up about.
Hey guys, can you kindly mute your phone? Can you please mute, excuse me, can you guys please mute your phone? Thank you.
I'm sorry. Okay, so like a job like project manager. There's a lot of companies that will have a lot of different project managers within the organization, and maybe people that work entirely from their desk. Okay, and they're managing different functions internally, bringing stuff together, and then there are managers that work out in the field. Question is, are those substantially similar jobs performed under substantially similar working conditions? If you say they are not, and if you have a discrepancy between males and females doing that job, it is your responsibility to substantiate why those jobs are different. Okay. You must, when you're putting these things, you must first group substantially similar employees. This is going to be the big paperwork part of this. for you, again, if you have any number of employees in a lot of different jobs. The who stage, as I call it. Question is, where are you going to find the information of these different positions? Now, if you're in the 1 in 10 companies that have updated job descriptions, you've got a very good place to start. If you're not one of those 1 in 10, you're going to have to take a look at your job descriptions to see how accurately they describe the positions involved. There are a lot of different ways to put your job descriptions together. I'm holding one up to the right now. I'm sure you can see it, but it's a beautiful job description created, oh yeah, by me. And what the job descriptions that I've created do, they identify the title, you know, the hours, the number of people and the complexity of people supervised, whether it's exempt, non-exempt, and it goes into essential functions, and that's the key. What are the essential functions of the job? Because that's what you're going to be comparing. And you're going to be comparing them against perhaps other positions with different titles. And again, under the law, it doesn't matter what you say the position title is. It's going to be whether it's substantially similar work. Okay? So, and then finally, your job description should look for the physical and mental demands of the position. It quite often is the jobs are going to be different based on the physical and mental demands that you're requiring of the person. So if this is position A, for example, has tight deadlines and working with customers, clients, and you're always under pressure, versus another position where it looks like it's the same, but it's an internal function, and you're not under those kinds of tight deadlines. That's a distinction that you can use to differentiate positions, particularly if you've got a problem. Okay, so go into your job descriptions, make sure that you've got them, look at your format. Question about how should I format my job description, drop Priscilla a note, and we'll shoot you a copy of the job description that you can use to follow. As a template. Okay. Okay. So when you're developing these comparisons, a good place to start, identify the buckets of main groupings your company already uses. If you have a grading system, take a look at that. You want to pull similar functions families together, again, using the job descriptions that you hopefully have. If you have skill or job ladders, that's a big help. You probably don't. Those are prevalent in my public sector clients. Problem with this law, because they've got this thing down to the letter, and it's by their different statutes that they're complying with. But you do probably. So look for wage and hour classifications and other things that you think are important. Put similar jobs together. Okay, again, this is not going to come up. You're not going to have to deal with this until such a time that you have a disgruntled, probably female employee. It goes both ways, but unless it's a male working for Victoria's Secret and he's a minority, if mostly it's going to be females, and I'm upset with you, the boss, because I just heard Fred. I do, and I know my job's the same as his, and he ain't worth a darn. Okay, that's where it's going to come. And now you're going to have to explain your whole pay structure to somebody, and you probably haven't looked at that maybe ever. Okay, so that's why we wanted to have this thing today, because it's one of those things that's going to jump out, and it's written in such a way that it invites litigation. Question 4, are we allowed to take into consideration differences in job markets? For example, the market for employees in San Francisco is vastly different than it is for Fresno, okay? Okay. Here's what the law said, okay? It says employees need not work in the same establishment or region to make comparisons under the law, but considerations of geographic differentials will be justified. No, that's what it said. May still be just. That's obviously vague, and they did that on purpose. Okay. Yeah. There was an amendment passed to the law, which may give you an understanding of what's involved. Okay. Here is what the author of the law put in the register so that you can understand where they're coming from. And a lot of times, it's really important to understand where the heads are of the people that pass this legislation that you're forced to comply with.
Congratulations.
He said that the amendments to this bill that struck out work is performed at different geographic location and work is performed at different shifts at different times of day. Now that used to be what you could look at. They took that out of the law. Taking those out of the law should not be construed as the legislator's intent to make these factors available to an employer responding to a complaint. Rather, the employer may claim a bona fide factor that may be specifically described by the employer as well that is performed at different geographic locations or work that's performed at different shifts or times of day, etc. Okay. The thing here that you have to realize is that used to be a default, okay? Okay, the differences are they work in a different place, they work on a different shift, the working conditions are different. Well, that's fine, but now you've got to prove to who's ever looking at this, and this could be somebody from the state, or if the employee decides that they want to bring an individual action, this could be to the attorney and then later in the courts, that the distinctions that you made between this person's job and this person's job because they're in Fresno, not San Francisco, or they're working a shift, et cetera, or they're working outside, that those are significant factors that affect your job. Okay? So the burden is on you. Okay. So question number 5, does this mean that under the California Fair Pay Act, employees can be compared to employees in other states? Okay. I know that, I'm sure that some of you that are tuning in today have employees working in other states and they have different wage rates there and et cetera, et cetera. Unfortunately, nothing in the California Fair Pay Act explicitly prohibits such complaints.
Really?
In comparison. Okay? So you have, now, I think at some point they are going to clarify this. I hope to God that is the case. For right now, that is not the case. So when you're making your comparisons, you should take a look at people working in different states, different regions, etc. I think the good news is that California regulators are going to be far more interested in what you're paying California employees than what you're paying Georgia employees. So, I mean, this may not be a big deal. On the other hand, if you, say, have a bunch of employees working in New York City, paying a lot of money too, because it costs a lot of money to work and live in the New York City area, and those are all men, and your California operation is in a lower pay area, you're going to I think you're going to have to deal with that. So just be prepared. What are the factors that employers may legitimately use to explain different? Hey, what can you look to? Okay, we went through this at the beginning: seniority system, a merit system, quantity and quality of production, like piecework. Those were in the old law. Those probably aren't going to have a big factor. What's going to have a big factor is this final thing, a bona fide factor other than sex. So education, experience, training, certifications, geographic differences, if you can, that there's clearly a difference. And in that regard, geographic distance, I should have covered before. If you do a pay comparison, if you're looking to see if you are paid fairly or your people are paid fairly, you might go to one of the salary surveys that are out there. You know, Indeed or Pay Scale or one of those things. You will see that it is often mentioned in those that there is a regional difference that you as employer have to take into consideration from their point of view in making job offers. Okay, so you can use that. Would be good information for you to pull in. So it's not just you saying, well, of course it costs more to do business in San Francisco or Walnut Creek or wherever you are versus somewhere else. But the fact that you say so and the fact that that's the truth is not going to hold as much weight as if you can bring in other sources that says the same thing. So when you're taking a look at positions, geographic, education, experience, training, certifications, where are you going to find this information within your records to say why that makes a difference? Answer: that should be in your job description, and the job description's got to match the job that you're actually looking at. So if you need a 4-year degree to do a position, that job description ought to say, okay, experience, how much experience is needed, all these kinds of things, as specific as you can be in defining what's required of the job, is going to help you a lot when you go back to make comparisons. Okay. Okay, now we're getting into kind of the second major differentiation that you're going to deal with, and that is one of the main reasons employees are paid different amounts is because they were paid different amounts by the prior employer. So every employer takes this into account. Is this not permitted? Okay, so saying that another way, I'm hiring 2 people for the same job, and one of them is coming in and has made $60,000 a year. The other one is coming in and has only made $55,000 a year, and you've got to decide what you're going to pay them. Okay, with normal kinds of salary negotiations, you're going to feel like you've got some slack to pay the person with the lesser salary, that you're going to be able to pay them less money. But one of the things that you have to consider under this law is, are you paying people different wages to do kind of work, irrespective of what they earned before? So this is a major change in the way we looked at things, at least most that we were looking at. Okay. California law does not prohibit, and I put it in there at least yet, inquiring about prior salary. The legislative history references that such inquiries, however, could perpetuate wage discrimination. Okay. interpret that for you. That's a precursor, okay? They're saying, yeah, you can do it, but no, we don't like it. And this could perpetuate further discrimination. So if you're hiring a bunch of people and some of them are women and some of them have worked in jobs where they weren't paid as much, the fact that you're offering them salaries to do the same job as you're paying somebody else, a male, to do that job who negotiated better and was making more money. If that throws your system off, you're in trouble. On a positive side, prior salary often reflects differences in skills, experience, and performance. My suggestion to you is when you are interviewing people that you document exactly what that person was doing, exactly what that job entailed, matching that to your position, and then using that as a basis for justifying any differentiations that you've got. I threw at the bottom here, warning. This law would forbid, absolutely forbid you inquiring about prior salary history. When I ask, will California be far behind? My guess is no. Okay. Okay. In the same vein, what about salary negotiations? Are we still able to negotiate with candidates? Well, as I listed before, you've got some considerations that you have to consider. Yeah, you can negotiate. Yeah, you should be able to negotiate. But you've got to keep one eye out to see where the salary negotiated is going to put your candidates that you turn into employees within your structure. Okay? Are you still going to be able to negotiate? Can you still do it and still meet the requirements of the law? Looking at it a little bit different way, here's what happens. I hire Priscilla, and she's smart, and she's sitting right here next to me, and if I said anything different, I get hit. Okay, she's smart, and then I hire Rob, he's Rob. Okay, so Priscilla was making less money than Rob at her prior job, so I hire Priscilla, who was making 50. I hire her at 55 because I'm a good guy. And then, well, let's just say we hire her at 50 because I was going to match my figures here. And then I hire Rob at 55. Okay, they've got a $5,000 spread. Okay, so let's assume that they're both excellent employees, which is certainly true in Priscilla's case. And so they're going to get 6% wage increases for, say, 5 years. Well, 5 years out, when you're working off a bigger base, you're going to be making that spread over the lesser employee in terms of wages is going to spread. So your $5,000 becomes like $8,000 to $9,000. Put it in bigger numbers. If you're dealing with six-figure people, what that's going to do. Okay? So what I'm saying to you, which probably is different than what you're doing now, I think you ought to be able to hire people at fit rate, at the rate you think is appropriate for the job. If you get somebody that's way under what you think the job is worth, you're running, and it's a woman, you are running a risk of paying that person, even giving them a decent raise if it's going to put them substantially under what you're paying other people doing the job. Okay? Now you can take all these things into consideration, and anything that you can justify, good. Okay? And I'm not saying that you have to pay everybody the same amount of money. There are big differences in background when they're coming in, and certainly big differences in performance. uh, document at some point in time, like annually with your performance evaluation cycle, you ought to be taking a look at where you are. And if there's discrepancies in your system, you ought to be looking at ways to mitigate that, okay? If you do not, you're going to have a problem. And again, once litigation on this thing, just think about it. You're going to have to justify your whole wage and salary system within your company. Even if you don't get tagged for a big penalty fine, whatever, the amount of man hours that are required to deal with this litigation and hiring attorneys and such, it's a real pain. So the reason I wanted to have this seminar today is that I think this thing has gone under the radar. It has not had the same effect as some of the where you knew you had to do something right now and you did it, and it was, you know, it may have cost you money, but it was simpler and you knew what it was going to do. This thing has fish hooks, and this thing can be really significant. So look at your system. Okay. Salary negotiations. I had a discussion a couple days ago with one of my who owns her own company, and she knew about this law, and she said, Lee, here's the thing that I run into. I have a woman who will apply for a job, and then I ask her, well, what salary were you hoping to receive? And I'll get a nebulous answer. If I'm hiring a man for the same position, these are obviously our generalizations, I'm going to get a number, okay? So if I'm pushing to meet the number and sliding on the person who with nebulous answer is going to create problems. So you can't do that anymore. Okay, so salary negotiations are not expressly prohibited by the Act. The differences in starting salaries offered would need to be justified as a bona fide difference other than sex. Okay, the fact that one person is a better negotiator than the other is going to fall on deaf ears. Okay, the burden is on you to distinguish between what you started employee A versus employee B, and you're going to be able to show somebody who doesn't know anything about your business and if they're working for the state, doesn't trust you anyway, what's going on, okay, and why you did what you did. And they're going to start from the perception that you don't want to pay people anything like you should be because they think. Differences in starting salaries must be job related with respect to the position in question. At least theoretically can be justified with a business necessity. And I said theoretically because proving a business necessity is going to be the challenge. The factor relied upon fulfills the business purpose it's supposed to serve. So if you have an X, they have to go, the law firm that I use when I need employment advice, it's called Cypher Shaw, and they have offices all over the world, including San Francisco. Matter of fact, they help provide a lot of the information we're discussing today. Okay, Cypher Shaw has some of the brightest people in the world, but at least at one time they recruited from Harvard, and they recruited from Stanford, and they recruited from Yale, and about no other place. Okay, so Cal Berkeley, of course. So, but they said that was a business necessity. These are the kinds of people that we need. Well, if that disparities, then they're going to have to prove to somebody, if they're working in California, that that necessity, that was in fact a business necessity, and it's going to be difficult, frankly, to do that. So you should be aware that that's what this is not hopeless, but it's going to take some work. Okay. Okay, what damages can be awarded under the law? if someone brings an action and you're found to wages and interest plus an equal amount as liquidated damages and reasonable attorney fees. Some would say that that's an oxymoron, but reasonable attorney fees. Willful violations may commence no later than 3 years after the cause of action occurs. Generally speaking, there's a 2-year statute of limitations on this thing. Okay? But I'm saying to you that the damages under this law may be the smaller amount as compared to the amount of work that you're going to have to do if you haven't put your house in order for wage and salary systems, and you have to try to justify everything that you've done. Okay, so getting down to the end, key question. How can we effectively evaluate our risk under this act and put in place a game plan to avoid liability? Okay. To comply with the law and mitigate risk, most employers will need to change their compensation philosophy and practices and its policies dealing with confidentiality with salary levels. This will include reviewing how starting salaries are determined and how the internal comp program works. Okay, so you got to take a fresh look at this. Okay, I've got to comply with the law. I've got to see where I'm going. I've got to make sure that I'm paying females as much as males, and if I'm not, that there's reasons why. Okay, person by person. You have to eliminate policies that forbid disclosing compensation level. Employers may not prohibit employees from inquiring about, discussing, or disclosing wage information. Now, that was always the law, but it was not a big thing and it was never enforced. This will be brought to the forefront, and if you get some manager that doesn't know that this is the case, and if they get all over somebody for talking about what they're paid versus else that are paid and da-da-da-da-da-da-da, okay, that is going to set you up for a harassment complaint under this law. So your managers have to know that this is the case, okay? So salaries have to be transparent. You have to update your record retention program to maintain records of employees' wages and rates of pay, job classifications, etc. For a 3-year period. The old law required that you keep these records for 2 years. You now have to keep them for 3 years. I don't know that that's a big deal because most of the employers that I work with okay, so but you've got to keep them up to speed. 3 years minimum. Okay. Like all of us HR type consultants always tell you, document, document, document. Defining substantially similar positions is going to be a tough job. To even have a shot at this, you're going to have to compare relative skills, efforts, responsibility, and working conditions to distinguish from another. There's lots of ways to do this. I am not a wage and salary maven, so I will not get in with you into the intricacies of doing this. But there are people that are out there that live for that, and God love them, and they're all going to be making lots more money pretty soon. Okay, but you can use a job matrix. I suggest that you do that anyway as a hiring tool, so that you don't get somebody in there that just blows you away because they interview well, and then you look at your matrix and say, well, great interviewer, but doesn't have this, doesn't have this, doesn't have this, and I've already said that this is important. So your job matrix lists the essential functions of the job and weight them, and that's a good comparison. Your job evaluation system. I don't know which or managers hate worse, putting together and working on job descriptions or doing performance evaluations. Probably the latter. Systems now have become much more important. Okay? Number one, you've got to be evaluating people based on the essential functions of the job. Those things that you are going to put forward to justify why you are paying people different amounts of money. Fred is a nice guy and he's doing a good job like he always did for the last 20 years. It's not going to cut it anymore, okay? So you need to develop a good evaluation system. It's not that hard. Decent job descriptions, and you can, when you put together an evaluation for a position, you ought to be looking at how the person is performing those key things in job description, okay? Okay. The factors that influence pay determine what does or should determine paying people. Really look at these factors. That number 4 on the list from before: experience, education, starting pay, market, stars, things. Make sure that you've got a very logical system. Okay.
There's no personal quoting.
Where should we go? Okay, so we get there. Okay, group substantially similar employees, substantially similar jobs. Okay, you're going to need to get your key managers involved, I think, in this process. I think that is not realistic. So you're going to have to get your supervisors, managers involved in this and take a look at these, particularly where you know that you've got a problem, okay? Evaluate permitted factors, pay differences, okay? The things that we've been talking about. Analyze your pay structure. Take a look and see where you are. Don't start by looking at what you're paying people and then try to backfill it to explain it, okay? What you should be doing is looking at the system and then seeing where people. Then finally modify your policies and practices to allow you to keep up with the law, okay? So if you are, the two keys are, number 1, what you're paying people when you first bring them in, and number 2, how you're managing the system going through. Again, you may have to, on occasion, square your system up based on discrepancies that you find. And you're not going to reduce anybody's salary, so you're going to probably wind up increasing people's salary a bit. Okay? So, but make sure that you do that. This is going to take a lot of time, I think, unless, unless you're a smaller company, it's not a big deal. But if you've got a lot of complexities, you've got people working all over hither and yon, you're going to have to determine that you're going to have to spend some hours doing this, and you probably should make a budget in case you've got to make some realignment within your pay. Best time to implement that probably is during your employment section, your annual evaluation time. Okay. Policies and practice. Review your employee handbook to remove any prohibition on employees disclosing their compensation to others. You're already going to be re-looking at your handbook because of the first thing I started with, to make sure that you've got a good sexual harassment program that people can look at them. So while you're doing that, do that as well. Update your retaliation policy. You cannot retaliate against someone that raises a complaint about what they're being paid. This law specifically prohibits that, and that's going to get you in a whole bunch of problems. Modify your code of conduct if necessary to allow people to file complaints that, you know, regarding pay. If you're a good if you have good managers that listen to people, these issues will come up and you can take it. Make sure your record retention is for at least 3 years. Your managers and everybody that you need to of what the law requires. Okay. So that's kind of it. Okay. Again, this is something that's going to lay in the weeds, I'm afraid, for some time until the plaintiff bar really starts bringing some cases. And I'm afraid that most employers are going to be unprepared to justify pay differentials. If that's the case, lawyers are going to figure out they can make doing this. Okay. Also, it creates a lot of bitching within your own company if all these issues of pay keep doing. So start now, plan ahead, do the kinds of that you need to do, and get your system in order. Okay? If you have questions and things, if you think there's some way that we can be of help to you, run your questions through Priscilla. She'll send them to me. She knows where I live, so I can't avoid her. So, you know, and I'll be happy to help to the extent that I can. But this is real, and I think it's only the beginning. So true up your system, make sure everybody's being paid fairly as the law defines it, and you'll be in good shape. Okay?
So I will be posting this recorded webinar on our AccessHR website, as well as emailing you recorded, as well as the slideshows. You can email me at thenley@accessehr.com or email the benefits desk, and we will make sure that this session gets to you. And please be sure to reach out to us with any specifics you have, so we can help customize it best fit your company that you're here for. That's the value add. So with that, appreciate everybody listening in, and we look forward to hopefully answering any questions that you have.
Thank you.